Welcome to From the Clinic to the Courtroom, Health Law Unpacked.
Hello and welcome to From the Clinic to the Courtroom, Health Law Unpacked with MariaTSantiEsq, founder and managing partner of the Health and Medicine Law Firm. Maria and her team are focused on providing exceptional legal services with efficiency, accuracy, attention to detail, and a high work ethic. I am your host, Kevin Rosenquist, and today we're going to talk about if you can really sue your insurance company. The answer is yes, and now you're going to find out how. Maria, welcome back.
Thank you so much for having me back.
All right. I want to sue my insurance company. I need your help. Okay.
Got it. That's what we're here for.
We're there for. That's right. So when does a denied claim become something that you can actually sue your insurance company for?
Okay. Well, I mean, that's a broad question. There's many steps. But so as we've talked in other episodes, the first thing is going through the appeals process, make sure that you did everything you could to try to get this resolved. I'm always like dumbfounded when I'm talking about healthcare and somebody's health, because you don't need to do this for anything else, but they make you do this to get healthy.
For your well-being, for your physical well-being. Yeah.
Yeah. So basically, once all the appeals have been done and there's nothing else that can be done, now this is the time where, yes, you definitely now have to meet with a lawyer. That's where we would step in with our clients. When they come to us, they have tried everything and they say, well, I really need this medication and I've done everything and I can't get it and I can't afford it. So what can I do now? And a lot of times it's a person can't afford it, right? Some people can, and then we just sue to get the money back. But there's some that really can't afford to pay for this treatment out of pocket. So now we're like here just doing our best to try to get them the health care that they need. So we first have to review all the appeals, all the paperwork that went back and forth between the patient, the insurance company. We have to look at why the insurance company denied the coverage for whatever it is they're denying. I mean, there's so many things. It could be surgery. It could be a hospital visit. Yeah. It can be a medication. It can be cancer treatment. So basically anything. So then at that point, we look at the policy, we look at the denials, we look at any favorable laws that would help us in this type of litigation. And then if everything lines up and we say, well, yes, there is a good argument to get this coverage under the policy, then at that point, we talk to the patient. They say, yes, I want to sue. And then with, a technicality is you have to do an engagement letter with a lawyer as far as how, if there's going to be payment, how is that going to happen? Is it going to be contingency or not? Depending on the case. So then at that point, once that's done, and all the information is reviewed, the complaint gets drafted. And at that point, that then gets filed with the court. Along with the complaint goes some other documents that might be discovery. There's a document that's called a summons that we have to send with the complaint that tells the insurance company that they have to answer our lawsuit. So at that point, we have gone through all the details. I have staff in my office, for example, that we have a patient advocate that she puts together the medical bills charts and tells us, okay, well, how much is at issue? What's being denied? We have somebody that helps with drafting of the complaints to make sure that all the details are accurate, that the policies are looked at. And then we have someone that actually does the actual filing. So like at that point, the patient really isn't involved. It's just they made the decision. They said, I'm going for it because I really need this treatment. And then we take it from there and we go through the litigation process with the courts.
You mentioned like some people can't afford certain like prescriptions and stuff. I mean, I've heard of prescriptions being tens of thousands of dollars per month and some at times. And I mean, yeah, who can afford that?
Yeah, I mean, there are some, few people that can, but yeah, most people cannot afford certain medications or prescriptions that can be, like you're saying, in the thousands, $7,000 to $10,000 a month, especially when we're talking about cancer treatment.
Yeah.
So in that situation, I mean, so I will mention, so I've had to do lawsuits to get a terminally ill cancer patient treatment because they denied prescription medication. And this was in the tens of thousands of dollars every month. And then at that point, you might try to do an emergency appeal, but you don't have time for appeals because if this person doesn't get the treatment, they're going to die. Like,
Right.
that's just the plain reality of it. So in situations like that, like we get an emergency injunction filed with the complaint and ask for an emergency hearing immediately with a judge when it has to do with treatment that could put a patient's life at risk. That's one of the most, I would say like triage kind of situation that we have seen several times.
That's sad for sure.
Yeah.
What about misconduct, bad faith? Like, do these kind of things ever happen with insurance companies that have legal ramifications?
Yes. So, I mean, in the state of Florida, bad faith is a little tricky, and there are restrictions and certain things, but there are situations where somebody could take the position that the insurance company acted in bad faith. And all of that is outlined in our Florida statutes. They have the reasons why an insurer could be held liable for bad faith, which would entitle the patient to additional damages other than what would be paid under the policy. So you're not just getting the treatment or the coverage, you're also suing for damages above and beyond, like maybe emotional distress, or maybe your relationship with your family went bad, or maybe you got permanent damage, or all these sorts of things. So to have bad faith, there has to be either miscommunication from the insurance company. They weren't transparent. They were inconsistent. I mean, it's very detailed as far as it's outlined in the Florida statutes. So it is something that can be done, but they do also have a right to cure. So essentially, if an insurer is accused of bad faith, they have 60 days to fix it. And if they fix it, many times that's it. You can't sue for bad faith, but it is something that is possible depending on their behavior and what they did with this particular person or the claim.
Okay. Is suing an insurance company different from like a typical lawsuit, if you will?
Not really. I wouldn't say it's different because it depends on the cause of action for which the health insurance company is getting sued. So if it's, for example, a breach of contract, that's going to be very similar to any other breach of contract that you have with any other type of policy. But if we're talking about the federal employer plans and you have to do it under the ERISA laws, now that's going to be a completely different kind of lawsuit than any other lawsuit. Okay. And it has to be very specific. If you're suing, like now there's a section under the Affordable Care Act, section 1557, that prohibits discrimination by a health insurer. And people can sue if they're discriminated against by an insurance company, on the basis of race, sex, nationality, I believe is another one, disability. So if there's something showing that they were discriminated against, they can sue their health insurer in addition to the coverage, but that would definitely be a completely different type of lawsuit than a regular lawsuit. Mm-hmm. But the process in courts, they're all the same, like any other lawsuit. The one thing that I was just thinking of now is the Medicaid and Medicare. Those have different processes that are not necessarily, you're not suing because you're required to do those administrative law judge hearings. So that's going to be a little different than suing in court.
Okay. And what are we looking at timeline wise for a case, for a trial or after you sue? I suppose it depends on how far it goes, right?
Yeah, it definitely depends on how far it goes and whether or not the health insurance company would like to settle the claim or not. Mm-hmm. It can be anywhere from 3 months to 2 years, depending on the specific issues and depending on largely on the health insurance company, because if they want to fight it, they will, and they have absolutely zero compassion. They don't care. They will spend way over what the surgery would cost or what a prescription would cost. Like they really have zero compassion. So like I had a case once where a lady, she needed surgery, a back surgery. And I think I may have mentioned this in a prior episode, but it went to litigation and she was fighting. And it was very clear that there was no other option for her. And this law firm and this insurance company litigated for over almost 3 years. And she's there in pain every single day. And they just kept fighting and fighting, and we just fought to the end. And it was just, I mean, that's what they do. Like if they want to take 2 years, they don't care. They just don't care.
That seems so ridiculous, doesn't it? Like why?
It is.
Yeah, I mean, you could have used a fraction of the money to help this poor person, but no, you have to like fight just because.
Yeah, I still haven't figured that one out. Sometimes they do resolve issues that are, if they think, this doesn't seem worth fighting, but other times I don't understand why. And yeah, it does seem ridiculous. So I don't know. I mean, I don't know if it's coming from the actual health insurance company or the law firm that they work with. Like, there's no way for me to know who's behind this unnecessary litigation. But I do think one of the factors that comes into play is the fact that, like I've said before, not many attorneys do health insurance. So the law in this area is not very well established. So there's a lot of gray area. So then they feel compelled to make all these arguments instead of just looking at the fact that somebody just needs medical treatment. And it's that easy. Like we're not talking about $1 billion contract or $1 million contract. They just need medicine or a surgery, or it was a $20,000 procedure. That's all it is. It's not very complicated, but they make it as complicated as they can if they can.
Man, that's sad. That's sad on a lot of levels.
It is very sad.
Do you find that would you say that they settle more than let it go to trial, or vice versa, or what do you think?
So I think statistically most cases do settle. So I would say 90% of cases will settle.
Oh, wow. Okay.
Yeah, they will settle. It's just the length of time because, like I said, they just fight. And I think part of the reason, like I said, is because not many attorneys do this. And they're kind of just trying, like on my end, right? They're like, well, let's try to wear this attorney out. So they just give up. Mm-hmm. And I feel like that's probably one of the motivations, or, even the health insurance companies, they might be like, oh, here comes MariaTSanti again. Just drop all this, go ahead and drop all these motions on her. Because I'm just telling you from experience. I know that sounds very cynical, but sometimes there's just no logical reason. And, all I want to say is that we're not giving up. My staff and I, we are committed to the end, and we will fight until we need to fight. And hopefully, and even further to, change the law. We do appeals too. Like if they continue to fight and it's something a judge may not even understand because it is complicated. It's not an easy area. We do an appeal and then let the higher courts decide. So we have had some case law come out of this, and that's where, we go all the way for sure.
Well, don't worry. I'm pretty sure that pretty much anybody you talk to, us regular folks, are cynical about insurance. So I think you're in good company there for sure. Your example about the 3 years, I mean, how do you drag it out that long? Just filing motions and dragging your feet and that kind of stuff?
Yes, pretty much. I mean, it's taking depositions, a lot of technicalities. Like a lot of times they'll file a motion to dismiss, for example, and then it takes you months to get a hearing with a judge. So you have to wait for that. Then they typically those motions get denied because it's a very low standard. Like you have a right to sue. That's what the whole, our right in the United States is to bring legal action. So a lot of times those motions are just a waste of time to delay. They really do delay things. And then they file different motions, motion to strike this, motion to strike whatever, all kinds of things. Like if they can find an argument, they will file something. And then it's just the process of the courts to, like in Florida, at least our courts are very overwhelmed. And sometimes you can't get a hearing right away with a judge, and that delays the case. And then we also have to go through discovery where we answer questions back and forth, and we have witnesses that we need to depose and take depositions, and life happens too. Like sometimes opposing counsel may have an emergency, or I may have something and we have to postpone. But typically it's just mostly, I would say, just the filing of motions and the judge's availability and the court system that is not always available.
Do you think that a lot of people don't realize that they can sue an insurance company?
Yeah, I think for health insurance specifically, I think a lot of people realize they don't know that they can sue a health insurance company. I think a lot of people know they can sue, like when they get into a car accident, they can sue when their property suffers damage, but they don't, not many. I mean, people are starting to learn, but not very many people know that they can sue health insurance companies. I think that's something people are starting to learn, and hence why we see a lot of arguments that are in the gray area, because not a lot of law has been established in this sector.
Yeah, it's a weird thing. It's like something we seem to just accept. Health insurance, we're just like, well, they said no, or a lot of times, people don't realize like, hey, no, you have rights. This isn't like a, they don't get the final say. You do get to have an appeal process and all that. Do you think is it just lack of education? Why do so many people just trust the insurance company? Is it good marketing? Is it marketing?
I think it probably is lack of education, and just the fact that I think that's the way the whole industry works, really, where when you go to the doctor, most people are not going to question the doctor. They just see the white coat and they're like, yes, whatever you say, doctor.
Sure.
And then that's it. So then that kind of gets translated, I think, to the health insurance company as an extension of, well, this is the medical field. The doctor said I needed this, and now we just got to accept whatever this health insurance company says. So and because they have all those appeals too, like people may not know that, oh, I can go the next step. It's not just the appeals process.
Right. Yeah. That's a good point about the extension of the doctor. That makes a lot of sense. It's part of the healthcare system. So, well, that's the final say, or we have to trust that they are doing the right. That what they say is correct, but definitely not always the case.
Yep.
Yeah. All right. Well, thank you for tuning in to From the Clinic to the Courtroom, Health Law Unpacked with MariaTSantiEsq. To connect with Maria and her team, head to healthandmedicinelawfirm.com. And don't forget to subscribe to our channel and leave us a review. Maria, always great having you here. Thanks so much for your time.
Thank you for having me again.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.